Hi all, thanks for coming. I'm going to kick things off here while everyone finds their seats. I'm Becca Pincus, Director of the Polar Institute here at the Wilson Center, which is a foreign policy think tank here in Washington, D.C., and I'm grateful today to be partnering up with the Global Europe Program and the WABA Institute for Strategic Competition to put on today's event in partnership with the Embassy of Norway. So thank you all for joining us for this important conversation. We are honored today to be joined by a very special guest who's going to lead our conversation on protecting seabed infrastructure in the Arctic. Sitting to my left is Ambassador Rolf Einar Fife. He is Special Advisor at the Norwegian Ministry of Foreign Affairs and a member of the UN International Law Commission. He served as Ambassador of Norway to the European Union and to France, and has also served as Director General for Legal Affairs at the Foreign Ministry. So he is an expert in international maritime law, and we are honored to have him here for this conversation. Before we kick off, I would like to turn the microphone over to Mark Kennedy, who leads the WABA Institute for Strategic Competition, for a few brief remarks. Mark.
Thank you, Becca, and welcome all. It's a very important topic. We're very pleased to have this distinguished visitor talking about this issue. I'd say, first of all, my wife is half Norwegian, so we have lutefisk and lefse for all of our holiday meals. We feel right at home here, but I'm reminded, recently I am a civic leader supporting the Secretary of the Air Force, and they brought us up to Elmendorf and Eielson air bases in Alaska. And one of the things that stuck with me was that it's closer to go from Alaska to Beijing than from Honolulu to Beijing. It's closer to go from Alaska to Moscow than from DC to Moscow. And why that matters here is that when you think about undersea cables, speed matters. And having an undersea cable going through the Arctic for communications is 30 to 40% quicker to go from London to Tokyo than elsewhere. Also, now that we're very pleased to be welcoming Finland and Sweden into NATO, the route that we're talking about means we're all going through NATO countries as opposed to have to worry about data possibly being intercepted or interrupted elsewhere. So these undersea cables are of vital importance. Data, we live in a world of data. Data is power. Control over it, ability to intercept it is vital. And so having that security is important, and at the base of it, having that rule of law defined is something that will give us a much better leg to stand on. So I can't imagine a more important topic for us to be talking about with our good friends from the North, and welcome. Look forward to a vibrant conversation.
Thank you so much. So as we kick off, Ambassador, I would just like you to start off with a few introductory comments, if you don't mind, on why this topic is so timely. Mark has sketched out some of the really important contours here, but from a Norwegian perspective, you've had some direct experience with attacks on seabed infrastructure in recent months, and so I'm sure you're well prepared to explain to us why this is a topic of growing importance. Thank you.
And the cooperation between the Wilson Center and our embassy, and we cherish that. And also delighted by all of you who've come to listen to this and participate in this conversation, which I understand is going to be very, very interactive for you, Rebecca. So thanks a lot. I thought the best I could do would be to share with you some reflections. They're more of a personal nature, so nothing of what I say, I have to say that as a foreign service person, is a statement of the Norwegian government. It's more a reflection around some of the stakes, some of the possibilities. And I think this particular topic is, for the reasons you explained, Mark, very, very timely. And I think to start up at the outset, I would try to sort of reassure you that there is a legal framework. It's because, you know, when international lawyers meet, they often focus and narrow down on gaps. Where is there a gap? And that creates a lot of anxiety and questions as to, you know, how can we fill those gaps? I would like to start in the other end, basically ask, you know, at the beginning there was a huge gap before you had international law, but we have, in this particular case, a body of law which I think is extremely useful and which reflects very carefully key strategic interests we have. So if I may just show you a couple of initial reflections there, and say that the first sort of big technological breakthrough or revolution that took place, where chancelleries and governments suddenly thought, wow, this is a major game changer because we have now critical subsea infrastructure that is going to change the rules of the game. That was when the first telegraph cable was well connected, basically Ireland to Newfoundland. We're talking about not the 20th century, we're talking about the century before that. So there was a kind of, if you go back to the proceedings from the time, what I would call a crisis meeting that was held in Paris with attendance of quite a large number of governments. And it ended up by the drawing up of the Telegraph Convention, the Telegraph Cable Convention, in 1884. And they said, this is so important, let's see how it works. Because it's, basically, you referred, Mark, to distances and time. Messages sent through subsea cables at the time changed totally the perception of possibilities, whether civil, military, what have you. So one needed to grasp what the stakes were. And the Telegraph Convention is still there. It's still there. And it has some elements which are useful for more than just telegraph conventions, telegraph cables. Let me just say that I think there's a consensus that they also apply for fiber optic. It applies for fiber optic cables and electricity cables, and not just for telegraph purposes. Now, since then we have different conventions that have come into play, but they build on the same system. So those who basically say there's a lack of clarity about the fundamentals. In international law, we tend usually to think that it's essential to understand, well, how long have we had some rules or principles? Have they been generally recognized and accepted? And if there's been no opposition to it over, for instance, in this case, more than 100 years, there's a strong, at least a working hypothesis that those rules are not only binding on those states who joined the particular convention. This is customary law. So in general, I think we have one of the oldest examples of an international effort to establish a kind of legal order that will reflect key strategic interests connected to pretty exposed critical subsea infrastructure. Now, what has happened since, if you take, for instance, the big modern law of the sea reforms that took place and ended up in the UN Convention on Law of the Sea of 1982, basically builds on what was established very early on. That is that the freedom of communication is a common, not only a common good, a common value, but it is of fundamental interest. So no one wanted to sort of question the value of unimpeded shipping, overflights over international waters, aviation, whether military, civilian, etc. And very early, there was this keen realization that this also applies to cables. So it belongs to what is referred to as the high seas freedoms. And where there is a very clear basis for saying that, you know, the coastal states where the cable starts and where it ends, or where it connects to a platform or an installation on the continental shelf, those states can put a number of conditions, and they are pretty free to decide on quite a few things. So what happened in the 20th century was that one added on the big question as to whether coastal states could start controlling larger zones, well, the continental shelf, for the purposes of resource management, environmental purposes, fisheries, 200-mile zones. But one was very careful in basically, and I think that's what was a strike of genius, reconciling, on the one hand, you could say the freedoms linked to, let's call it the value of being able to communicate and link up with others, interconnectivity, whether originally telegraph cables or high-powered fiber optic cables we are so dependent on today. And on the other hand, accept the notion that you could, as a coastal state, established on the basis of Truman Proclamation just after the Second World War, and then the Convention of the Sea and other things, control of the resources. Could be fish, living resources, or hydrocarbons, or etc. So there's a coexistence between the two. But the idea is that those two things are not one trumps the other. One has to pay due regard to each other. So there's been a kind of huge strategic compromise, I think state-of-the-art reconciliation of the needs of the military, of navies, of aviations, of cable layers, etc. And the whole idea now is, are those the developments that have been momentous? Do they expose this infrastructure to new kinds of challenges and threats with huger consequences than what interrupting a telegraph cable originally was? So there's, you could say the stakes have not become lesser. But my proposition to you is to say that the inherent usefulness of really using the legal order we have and not sort of imply that there's a basic fundamental lack of clarity. It's essential to basically make sure that you identify the clear link between what I would say is, on the one hand, geopolitics, our world economy, the internet, all of that, and on the other hand, the legal order. There's the two marry, they tie in. So I think that's my fundamental point I would like to raise. That is that it's not an issue of being in doubt about the foundations. It's more, what do we need to fix? And there is a conversation going on, which has to do with a number of issues. But again, it's possibly my role as a diplomat to reassure, but I would say, let's not risk challenging or putting into jeopardy what has been established brick by brick, so to speak, over many decades and now centuries, which is pretty essential. So I think some of the issues, the lawyers can be helpful, but I don't know whether the key issue is to identify fully all the issues of how to prosecute someone if, who is behind, who is instigating, inciting, or doing something, and, 10 years from now, can you prosecute that person? Is that the best deterrent or best protection for a cable? Or is the main issue right now detection of a problem, repairs? How quickly can we repair something? This critical infrastructure, how can we in reality utilize the partnerships between the private sector and governments? Identify whether the delineation of where you lay a cable, whether it matters, whether you do it there or there, whether you should invest in more cables so that you basically don't expose yourself to 100% vulnerability. We know that laying cables is expensive because you have to charter a particularly specialized ship to do so. And to repair, the time factor is very dependent on having the right kind of ship with the right kind of specialty on board. Now, that's costly. So I know there's a conversation out there as to, what would you want to have and what assets would you like to be able to mobilize very quickly and not have to wait in line if there is a major problem which affects several cables. And so I think that's not necessarily a legal gap. It's more a question of what are the consequences of new vulnerabilities, new geopolitical issues. So not to sort of divert from the law, but just say that not all the issues if you think of detecting something, are new technologies that can be used to identify a problem. How do you repair? How quickly can you do that? The question then is, is there a symbiotic relationship between cable owners, cable layers, governments, navies? There is a very interesting committee called the International Cable Protection Committee. It has more than 200 members. A large majority are corporations heavily engaged in owning, operating, repairing cables, or actually managing the shipping aspects related. There are also governmental institutions and agencies that are members. It's not a body which adopts new rules, but they come up with recommendations. And if those more than 200 stakeholders, key stakeholders, basically have a fundamentally same understanding, and I know there are quite a few US stakeholders who are ably represented in that committee, I think that also counts. One should listen to them. And one of the challenges here is also the issue with regard to cables ownership, because sometimes you have very complex contractual structures. Who is actually the owner? It's not necessarily a state. Now, where do I come from? Norway, Arctic country, has been heavily dependent on the regime for pipelines. Because we are, after, Russia, because of what happened with Ukraine 2022, Europe decided to relinquish its dependence on Russian gas exports. So Norway is the major supplier of gas, and we have 8,800 kilometers. If you add the length of all the submarine pipelines we have connecting us to European industry, consumers, etc., 8,800 kilometers. That's the length of Oslo-Bangkok. So, of course, it's a headache if you think of the need to protect all of that and have an idea of what to put. And pipeline is slightly different because it's something more in terms of dimensions and stakes, which is slightly different than a fiber optic cable, which is basically like a garden hose. And in shallow waters, it's usually dug underneath the seabed. Not necessarily easy to see, but identifiable in terms of placing. So we can come back to the law, but my initial point was let's not be naive about the fundamental importance of the legal order and of the UN Convention on the Sea for protecting our interests, which are of strategic nature.
Thank you. What a great rundown, and it's astonishing to think that there are nearly 150 years of legal architecture built around this freedom of communication and protecting submarine cables. So thank you for flagging that 1884 convention. I was not aware. I think maybe you can educate us a little bit on the importance of this seabed infrastructure that you've already flagged and the range of sort of possible state responses. Because I think you note that this infrastructure is becoming more and more important. And there are obviously important national security implications when fiber cables or gas pipelines are attacked. Is there a point at which this becomes an act of war? Is there a point at which a military response in terms of whether it's detection, whether it's repair, whether it's addressing the perpetrators, when military tools would be brought in, or does this say sort of strictly in criminal proceedings in the private sector? And as you mentioned, there's sort of a symbiosis. There's a relationship there, but is there a threshold? And I think specifically thinking about the episodes that we've seen in and around Norway in recent months, in the United States, we talk about sort of a frog sitting in a slowly heating pot of water, and you don't notice how bad things get because it's happening very slowly, right? And so I'm wondering if there's a point at which we should have a conversation about sort of red lines or triggers, right? Is this a soft threshold? So if you could talk about that a little bit, that'd be super helpful. Thank you.
Thank you so much. I won't delve too much into 1884, but there is a particular provision there which is pretty interesting. It's Article 10, which gives the possibility of boarding a vessel if there is a suspicion that something naughty is being carried out, which may affect a submarine cable. And I stand to be corrected by you, but last I checked, the only publicly invoked case where one actually, pursuant to that article, had a boarding was by the United States, a destroyer in 1959 outside of Newfoundland. It was against a Soviet vessel, the Novorossiysk. So, the things went well in the sense that it was a compliant boarding, and one had a discussion on board as to what the reasons were for what had happened. And of course, one of the questions was whether, I don't know the facts or particulars, but it had to do with the fact that there were bits and pieces of cable that had come up in a trawl or something like that. So it didn't become a sort of a major event during the Cold War, because one was able to basically very quickly, thanks to the US Navy, to identify or clarify as much as possible the facts surrounding this. So that's the one case of invoking at least recording such an event. So that's one element. The other is that the freedom to lay cables, pipelines is slightly different because you may have some environmental concerns, but it's basically the same. But you can basically be quite, rest assured that you have a freedom to decide on where to lay the cable. And you have cables who cross or transit through a number of states' continental shelves. Some of them, you can count them, and it's not as though the transiting coastal shelf state has a right of veto on it or whatever. But there's a possibility to require consideration of reasonable measures in order not to hamper or impact the exploration or exploitation of natural resources on the shelf. But that requires communication with the coastal state. But it's not a right of veto. I would be very sort of, not only as a Norwegian, but as an international lawyer, keen on saying there is a freedom of laying and operating and repairing cables. However, there are considerations of due regard that have to be taken into account, and the coastal state of transitive nature may put forward some views as to, please do not lay the cable right here because we have planned to drill a well and or establish some windmill, or and then one has, of course, to be aware of another fact. If you intellectually think of sucking out all the water from seas and oceans, what you will see is an incredible number of cables in some of those areas. So the issue of taking into consideration the existence of a prior cable is pretty essential. And the legal rules pertaining to the liability consequences are pretty clear. So I think that's the fundamentals. And for those who are particularly interested in those things, there's one article of the UN Convention on the Sea, which I think is expressive of customary international law applicable to all states. It's Article 79, which basically states exactly all of those things. So what to do with regard to a problem that suddenly arises? First of all, it's a question of identifying the facts. And that requires an effort and assets. And of course, very early interplay with the owner of the cable. Those who actually operate the cable are the first ones, and the end users who may discover that there's a problem. Has the cable been damaged? Has it been cut or interrupted, etc.? I think, if I should venture a personal reflection, I think there's a huge scope for using, in an appropriate manner, both remote sensing, satellite technology, and in the future, very creative forms of AI, to consider the pattern of navigation of a vessel, which may operate in a way which gives rise to, how to put it diplomatically, questions. So, you know, if a vessel, for instance, ceases to use a transponder and ways of identifying itself, AIS, etc., there are ways by, you know, by using the appropriate technology to nevertheless identify such a vessel. And depending on the pattern of navigating, it is not impossible, if you have recorded a few things, to consider whether this is actually a bona fide good faith fishing activity. You know, is there any fish in that area? What is the pattern traditionally followed by the vessel, whatever. Personally, I would think that's one of the nice things about artificial intelligence, that you won't need to hire 20 people to do an incredibly complex work of trying to trace the whereabouts of that particular ship or the previous fishing season, or what have you. So I think that is an issue more of to be governed by domestic law, in the sense that if there's anything that needs to be done is to promote effectiveness in the communication between those who have private stakeholder interests. Could be corporations who are engaged in maintaining, repairing, running a thing. Remember that those fiber optic cables would also rely heavily on software, you know, governing the wavelengths of, because this is light, a speed of light, signals that have been sent, and is not, as far as, again, I'm really not, I don't understand any of the science, but I have the impression that it's not easily done to say that across the Atlantic Ocean, what is happening on the internet or between two stock exchanges is duty-bound to follow one particular cable. Those data packets, they're sent wherever there is a quick access. The argument of reducing distances is fundamentally extremely interesting, because we've seen, and that is a conversation many of those who are engaged in this area considering, is that you have a degree of dependency on what is happening, for instance, in particular ocean areas where we have usually assumed there's no problem. Red Sea, Suez Canal, whatever, I don't know. So the Arctic Ocean might be the logical place to think of where can you reduce distances, where can you have some appropriate or adequate controls, and where do you have also some friendly neighbors, not all of them necessarily, but at least quite a few. Is there a sort of win-win approach there? And my key point there, Rebecca, is to say that the Arctic Ocean is not a lawless area. Yep. That in a couple of cases one still has to negotiate some maritime boundaries, but the fundamentals are pretty clear. That everything seems to indicate that most of the central part of the Arctic Ocean is covered by national continental shelves. Because there is this commission in New York which considers submissions made by coastal states as to the extent, the outer limits of the shelf. I was in charge of the Norwegian dossier and argued before the commission in New York. And we had our clarifications in 2009. So we were the first Arctic actor who clarified things. We don't have that large a shelf in the central Arctic Ocean. I think you do. That is, those of you of the US or Canada or Denmark, it's much more than the Norwegian sort of stake within the central part of the Arctic Ocean. I don't know if we have a map which could be shown. I think you will see that in terms of what, you know, the bread and butter issue for cables is very much linked to the topography of the seabed. And the big question for the commission in New York was to ascertain the nature of, you see those underwaters, mountain chains or submarine ridges, what have you, including the famous Lomonosov Ridge, which crosses the North Pole. You see this spectacular sort of mountain range? Well, the Commission has actually ascertained that it's linked to the Eurasian continent, so it's part of the prolongation of the Russian continental shelf. And I know that the US has carried out a huge piece of work and published its data, I think it was in December, unless I'm mistaken, last year. Without yet being a party to the Convention of the Sea, I would certainly applaud US becoming a party to it, because it's so fundamentally important to strategic interests, environmental interests. I mean, it's a win-win-win-win case, in my view. But the work has been carried out largely and expresses clearly the view which has been documented that, but still has to be considered at some point in a broader peer review. But the Chukchi Plateau is basically a prolongation, clearly, of you see it. You know, sometimes pictures speak louder than words. Mm-hmm. So now, fiber optic cables could be laid wherever you wish, actually, but there are not necessarily big advantages in going to the deepest parts. We haven't talked about electricity power cables. That's one big thing in Europe. They prefer shallower waters than the deeper waters. But fiber optic cables, you may wish to consider with Arctic conditions to basically think of shallower waters, maybe, in some cases, at least where you have national jurisdiction 120%, like from the baselines at 12 nautical miles territorial waters, whether US or Canadian or etc., you have full control. It's when you move outside of the 12 nautical miles that question of the freedoms arises, and where if you cross, let's call it a foreign continental shelf sector, the coastal state in question may ask for taking reasonable measures not to sort of hinder exploitation of natural resources. But you see a little here how the picture looks like. And then you can, of course, think of drawing in some places a route for a cable, which goes into very deep waters. I think the technology is extremely promising here. And there are ways of thinking that the politics of this may, in light of recent events, speak more in favor of looking at one part of the Central Arctic Ocean rather than another. I don't know, but it's certainly a big thing. In our case, in Norway, we are of course extremely keen on promoting as much information in real time through the combination of satellite collection of data or remote sensing and use of fiber optic cables in real time to basically promote our cooperation and our interests to the best possible use. And our friend in that context is the Royal Sea. And it's not sort of a discourse of the kind of saying the law is unclear and we need to have a huge international conference where all governments can sit down and try to refashion the law. Sorry, we're not part of that kind of discourse.
Yeah. Great. I know we're rapidly running out of time, and I want to get to questions from the group here in the room, and I've got a whole list of things I want to ask you about. So maybe just a couple of quick questions, and then we can cue the folks here to start coming up with their own. But you mentioned the extended continental shelf claims in the Arctic, and Russia has claims, obviously, in the Central Arctic Ocean, but those are overlapping claims to Denmark, to Danish Greenlandic claims, and to Canada, particularly along that Lomonosov Ridge. So can you talk about who would be the decider in an area where there is an overlapping claim? Could a company lay a cable there, or will cables have to wait until those overlapping claims are adjudicated?
It's a very good question. I think it has a lot to do with the quality of the communication and the relationship between the states concerned. Mm-hmm. Because basically, you have fundamental freedom, and then you have to take into consideration due regard some other interests. And that speaks in favor of talking together and ascertaining whether, well, you have actually plans for that particular area, which should influence the exact course of that cable, or not? Should we have some cooperation with regard to some kind of detection systems, policing, etc.? That could also be a case. I mean, the law is not an impediment for having a chat about that. I don't think it's necessarily useful to have to await the drawing of boundaries for the continental shelves, because this is fundamentally a freedom of the high seas, which where the existence of continental shelf is not a fundamental obstacle to the laying of cable or having shipping oil flights. But you have to take certain views into account. So the more scientific knowledge there is about the seabed somewhere, and I think, well, up to recently at least, there's been a quite phenomenally interesting exchange on a scientific basis between the coastal states up there. I was myself part of the meeting that took place in 2008 in the Ilulissat in Greenland, the declaration there, which was fundamentally very important, because irrespective of the fact that there may be nuances in terms of whether some or all are part of the UN Convention on the Sea, whether some had started on the mapping of the continental shelf, or whether remain boundary issues to be resolved, a number of things. The five basically stated, and Foreign Minister Rolf of the Russian Federation was there, among others, that basically we share a totally clear legal frame. The basic legal framework is there. And some of those issues up there, you know, it's pitch dark during winter. It's in some cases quite inhospitable, and the logistics are not easy. So I was personally struck by the fact that in the wake of that meeting in Ilulissat, there was a momentous increase in exchanges between various institutions on all sides. So I think there is ample opportunity for thinking that at least among some of those Arctic states, one could identify common interests in terms of cables. Mm-hmm. I don't see why not. And especially when NATO has at the Vilnius summit in 2023, of course, very much influenced by what had happened in the Baltic Sea. You may remember Nord Stream 2 thing, etc. That, well, maybe we should basically, I would say, polish our spectacles and basically realize that we have to take a second look, a serious look at critical infrastructure and try to identify what we can. You asked, Rebecca, a question about where might the threshold be for armed attack and armed conflict. The law of the sea does not actually regulate that, because it presupposes that, well, the Telegraph Convention 1884 says that those rules are not necessarily applicable in wartime. And the Law of the Sea Convention says that anything relating to the law of the sea is, of course, basically subordinate to the law represented by the UN Charter. So the right to exercise self-defense, to consider what constitutes an armed attack, all of that is not regulated by what I have referred to. And I think there's a huge argument that could be made in favor of not having too public a discussion about where exactly to define the level of intensity, frequency, or consequences of particular action, which might trigger some kind of response. I would just say the law of the sea is basically agnostic about that and not an impediment for saying that. But that's where I think it's important to know exactly who are the owners of the cables. And at the end of the day, the question of attribution is very important in international law. Who is actually behind what has happened? Who are the stakeholders? Yep. And what we've seen is the proliferation of cables with all kinds of stakeholders behind, and corporate structures with contractual arrangements. And I think quite a few of our authorities are looking carefully into those things. And this is a very practical matter. And so I would say it's not international law which is basically the fundamental problem here. We might need to add something at some point. But I don't expect that it would be for a global convention.
Thank you. The clock is winding down. If you have questions, I think we might be able to take one quick question. Evan, please. And if yes, turn your microphone on, please.
Quick, Ambassador Fife, thank you so much for being here today.
You just push the button.
Ambassador Fife, thank you so much for being here today. It's wonderful to see you here again. And you're the perfect sort of person with the right background for this type of topic. And I'm glad you've pointed to the importance of the use and reference to the current legal order. My sense of things, and you understand this area much better than I do, but that the status of cables in international law is relatively clear. But I wonder whether in your perch at the International Law Commission or discussions, IMO, or other sort of places, you have a sense of whether there are any disagreements among states when it comes to the status of the law related to subsea infrastructure. Are there discussions going along where either states or academics are not quite sure about what the conclusion should be?
Well, thank you so much, and delighted to see you again, Bloom. With your expertise, I'm also very honored by your presence here. Let me say that of course, whenever you have, particularly when you have a very mediatic event, as we've had in a few cases, you have a loud-sucking noise of views being expressed, and that's absolutely natural. And then you have lengthy periods of time where, if you look into the past, where those issues were not sort of considered to be particularly complicated. Now they seem to be much more at the forefront of concerns. I detect that there are, what is most interesting to see what the national legislation of certain states is. What do they require with regard to contacts, communication, or permissions with regard to the laying of a foreign cable over the continental shelf? And I note that France, for instance, is very keen on distinguishing between a foreign cable, so to speak, that would enter into their territorial waters, meaning the 12 nautical miles from the coastline, because then you need to apply formally for a number of reasons for a more comprehensive permission. But they do not have the similar requirement for a simple transiting of a cable. They, if I'm not mistaken, require notification. That is, please tell us, and then we can have a conversation about whether there is something concerning the exact delineation of where to go. I think that's an example. Without knowing the exact state of the law in France, I've just noted that legislation seems to me, prima facie, to be very much in conformity with the system. That is, everyone is basically also interested in knowing roughly where a cable is, because if you want to avoid the trawl cutting the cable, it's not necessarily secrecy, which is the best. And particularly if you consider a state that something is secret, it becomes very interesting. So I'm personally not sort of very keen on saying wherever there is some subsea infrastructure that is particularly interesting, to basically stake out publicly that, wow, this is a particularly interesting place. I would, on the contrary, be sort of more, as a matter of fact, into that. There are other states, however, who have requirements of permission, and particularly in a couple of other continents than the European or North American continent. So I would be, in terms of the developments of the law, I would take a keen interest in what the state practices. I think there is discussion as to whether some elements of, but that remains to be seen, some elements that stem from the 1884 instrument are sufficient, because you have a maximum, the power authority of a state is can be exercised to the maximum with regard to your own ships. So that when it comes to criminal prosecution, for instance, there's a fast track thing. But the problem nowadays can be that it's not obvious immediately what kind of, you can identify the flag state, you can board if there's something suspicious. But what happens next? Maybe just boarding is a good deterrent, I don't know. But there may be things to be looked into, but I would not suggest that those are fundamental gaps, which are per se an impediment for protecting critical infrastructure to in a manner which would be adequate. And there I think that a lot of practical cross-fertilization between private sector, government agencies, and between neighboring states, allies and friends, and basically sharing, in some cases, not necessarily extremely sensitive stuff, but having a kind of relatively common approach to things is good. Because at the end of the day, I think all states will suffer. I mean, the penetration of internet is mind-boggling, huge. It's not equal everywhere. I mean, in your societies, in Europe, it's key to basically everything now, economics and health, etc., etc. But the more it becomes so globally, the more you will have a huge number of states who will say, look, if you do something bad about some cable, it affects us, even us, which might not be immediately perceived to be the victims of something. So I would suggest humbly that cutting a cable and being caught red-handed is not a huge vote-getter around the membership of the United Nations. It's rather a pariah kind of activity. And I think it's good that it would be perceived to be detrimental to the interests of a huge number of interests, civilian populations, running hospitals, the internet, what have you. So let's keep a kind of appreciation of the global interests shared by all states in this freedom of operating cables.
Great. Thank you so much, and I think that's a great place to leave it. Thank you for your comments, for answering questions, for sticking around for lunch. I'd like to turn the microphone over briefly to Duncan Wood here for some closing comments, and then we'll give you a proper send-off. Thank you.
Thank you, Becca, and thank you, Ambassador. First of all, I'd like to congratulate Polar Institute, Becca, your leadership there. Thank you so much for putting this together, and Mark and the WABA Institute, and of course our Global Europe program. One of the most wonderful things about working at the Wilson Center is you see programs working together in a cross-cutting fashion, because so many of these issues don't actually fit neatly into one program. Ambassador, I want to congratulate you on a masterclass today. Legal, historical, technical, focus on international cooperation, collective action, information gathering, monitoring, a large dose of common sense, and let's not panic just yet. Let's stay calm. I think that's always welcome in these times. I'm particularly drawn to some of the implications of this conversation for something which I know that Norway is very interested in, and increasingly is part of our conversation here in Washington, which is about seabed mineral extraction. And of course, there have already been conversations, there are agreements between the International Seabed Authority and the International Cable authorities about how you can establish the right of way, etc., and which comes first. But I think that recent announcements by the Norwegian government that exploration is underway or will begin in earnest for seabed minerals, the announcement by the United States over the extended continental shelf, all of them bring to mind the fact that we need to be prepared and we need to be ready for these conversations when they happen. And lastly, in the spirit of strategic competition, I was talking with one of our experts, one of our fellows recently, about seabed mineral extraction, and the fact that unless the United States is out there, how do we know what some of the perhaps less friendly powers who are going to be engaged in this activity on the high seas, how do we know that their activities are actually legitimate? Are they really looking for minerals, or are they actually trying to map out our subsea infrastructure? And what kind of subsea infrastructure are they going to be building? And are we going to be fully aware of that? So I've enjoyed this conversation tremendously. Thank you so much for leading us. And once again, thank you to all of you for being here. Those of you who are watching online, I can't see a camera down there. Thank you for tuning into the Wilson Center, and we'll see you again very, very soon.
Thank you, Duncan. This concludes our webinar. Thank you so much. Thank you, Ambassador, for coming.